Hey guys. Hi. Just wanted to give here because I've been watching the YSNW Melly case, and I said while they're on lunch, let me go ahead and do my little commentary and come back and finish watching it. Well, anyway, I got some updates from the YSL Young Thug case. It's just so many why something, why this, why. But let me say hello to the folks in the chat. Hello, Lady Coltrane. Hey, Kimberly. Hey, Kia. Hey, Steph. Hey, VK. Hey, Rob. Nakinya. Mika's in the house. Hello, hello. Let's see who else. Hey, Nick. What's going on, Nick? All right, so I got all the folks that's in here and those that are not here who didn't put anything in the chat. I'm going to say a blanket hello. Hi, guys. All right. You guys did see my title, right? Well, when I was going, because I'm at the courthouse and we've been gone since last week and we're not coming back until the 10th. Court does not come back into session until the 10th. But in the meantime, attorneys are filing motions, things are being placed in there, and stuff is happening. So I do have some stuff for you guys. I have some updates and I have some footage. Some footage in regarding to they had a hearing last week, which did not occur. And remember the hearing in regarding to one of the attorneys that have that his computer was being used by one of the defendants, and the defendant was communicating with one of the officers, and the officer and the defendant was having something going on. The officer got arrested, and after she got arrested, she was charged, and she got a big old huge bond, $1 million bond. She couldn't get out and all that. So, all that. So, and so forth, right? So let me tell you what happened. I happened to be going through my footage, right? Just seeing what I had and stuff like that, because the hardship stuff is pretty boring. Somebody saying that they can't come because of childcare, somebody can't come because of money, the others can't come because of just stuff, because they don't want to be there, because the time, the length that it's going to take for this particular trial, it's going to be 6 to 9 months, and people don't have that time. Even if their job pays for it, they don't want to spend all that time there. Okay, well, let me tell you, so much drama has been going on in that courtroom in regarding to this. You have people passing drugs, you got people getting arrested for having their own medication. You have all kinds of craziness that's happening. You have more action than the actual hardship stuff, right? Got the judge being told off by a young lady, calling him a B. Then you have another person telling the judge that, hey, well, anyway, I got some footage. That was caught on a hot mic. And I don't think the judge realized he was on a hot mic. You get what I'm saying? And somebody sent the judge an email telling the judge that basically, but I'm going to let you hear the judge say it himself, what that person said. And I was like, whoa, you trying to tell this man how to run his courtroom? I feel so sorry for Judge Granville. I know y'all, he has a hard job. Shout out to Judge Granville, because let me tell you something. Whew, this man has to deal with a lie, y'all. He has to deal with a lie. But we're going to go here and we're going to play what happened. Poor Judge Granville. You got here, listen carefully what the judge said. Somebody sent him an email complaining. And they told him, I'm going to let you guys listen for yourself. All right. Shout out to everybody that's in the chat. But we're going to go ahead and play this, okay? This case is out. I mean, when I tell you it's out of hand, it's way out of hand. Way. So, I mean, look at the man's face. He's just like, oh, I'm just too through with this mess. Okay? Let's go ahead and listen what's being said. Hold on. It's not playing. Hold on a second. Do you see his face? He's just like, he's over this thing here. It's a little bit too much bearing on. And also, guys, I do have the most recent filing. You know, there's a lot of motions that has been filed that has not been even looked at. So I have that for you guys as well. Okay. All right, here we go. Let's see. See if we can get this man's thing to play. I don't know why it's not playing. Hold on. Okay, why is it not playing? Come on. Could you stop playing with me? Hold on. We gotta stop it and let it come back again. Hold on. Cause it's acting up. Just hold on a second. Just hold on. Just hey, Miss Spice. Hello everybody, Spice here. Hold on. It's locking up on me. Just a minute, just a second. Hold on, yeah, I got it going now. All right, the judge is here. Hi, everybody. Guys, you gotta remember this is the seventh group of jurors that came in now.
When I got an email from Clint Michael said I'm disrespecting. I think we had an email from him before. I said I was disrespecting the time.
You heard what the judge said? He got it. Hold on, y'all. We gotta stop this for a minute. Hold on. The judge got an email from somebody by the name of Michael saying that he said that the judge was disrespecting their time. And judge said he got an email from this person before. But this person told the judge that the judge is disrespecting their time. Let's hear it again. Hold on.
Court of Fulton County is now in session. Honorable Chief Judge Judge Granville presiding. Ladies and gentlemen, proceed.
from Clint Michael said I'm disrespecting. I think we got
Oh, why it stop? Oh my God, why did it stop right there? Where did it stop? What's going on here? It just stopped, y'all. Hold on, y'all. We gotta do it again. Hold on. I don't know why it's acting up on us. This little stupid gnat's in my way. Gnat's in my way.
Have seating, so we weren't doing
I got an email from Clint Michael said I'm disrespecting. I think we got an email from him before. I said I was disrespecting the time. I wonder if he's here.
I don't think it's us. I think it's just the recording the guy did. Yeah, the numbers are still going. It's not us. It's the recording. He got it muted. He got the whole thing muted and he got it paused. Because I was like, okay, just messed up. But the hearing is about to start in regarding to okay, let me do something. Let me kick this out and put it back in because for some strange reason it is acting up. Hold on. Me kick it out, boom, and then unplug it and plug it back in because it's being finicky right now. Okay. All right, let's hold on, y'all. Hold your horses. Hold your horses.
When I got an email from Clint Michael that said I'm disrespecting. I think we got an email from him before. And I said I was disrespecting the time. I wonder if he's here.
We're ready to start the hearing. Guys, what do you have to think about the time it's taking them for them to complete hardship? It's taking a lot of time.
Hi, good morning, council's interested parties. We're back on the record in the matter of the state of Georgia versus Khalif Adams et al. In 22 SC 183572. And the first order of business is to go ahead and take roll. All right, Mr. Beebe and Mr. Partridge.
Good morning, Judge.
Good morning, gentlemen. All right, Mr. Jackson and Mr. Boss and Mr. Sharp.
Good
Good
morning.
morning, gentlemen. Mr. Williams and Mr. Adams, good morning.
Good morning.
Mr. Kendrick and Mr. Weinstein, good morning. Mr. Huey and Mr. Matthews, good morning. Mr. Nichols and Mr. Harvey, good morning, sir.
Good morning. I got the whole team and everybody.
Oh, you got everybody? Okay, Mr. Gardner and Ms. Westmoreland, good morning to all of you.
With your permission, Judge, I will deal with a legal issue that dealt with all of us this morning. So, since everybody's here, with your permission, and Mr. Nichols' permission, can I absent myself?
Yes, you may, sir. Just give me a second. I'm almost to that point, and I think I'll be able to release you sufficiently, okay? All right, thank you, sir. All right, Mr. Dorsey and Mr. Jimenez. Good morning, gentlemen. And Mr. Ryan and Ms. D. Williams, good morning. All right. Mr. Delphine, good morning, sir.
Good morning, Your Honor. How are you?
I'm fine, sir. All right, I know you're handling this matter on by special designation. Good to see you again. I will take it up in just a minute. So, thank you, sir. All right, Mr. Randolph, good morning. And good morning, Ms. Von Kelsch.
Good morning, Your Honor.
All right, and I understand we have a bunch of interns this morning. Interns, go ahead and stand up. You didn't think you were going to sit down here for free freight, did you? All right, so tell us where you're from and what are you studying? Start out with the lady in the pink.
Oh, my name is Salma, and I'm interning for Mr. Jimenez.
Okay, all right, welcome back. Okay, all right. Madam?
My name is Madison. I'm interning for Mrs. Lawson.
Okay,
My name is Nana, and I'm interning for Judge Adams.
okay, where are you studying?
I'm studying high school.
And are you in high school or in college or in law school?
I'm a high schooler.
Okay, all right. So you're interested in maybe going to law school one day?
Yes.
Okay, madam?
My name is Naya, and I'm interning with Judge Adams, and I'm in high school.
Okay, wonderful.
Hi, my name is Kelsey. I go to Georgia State and I'm studying political science.
All right, welcome.
My name is Josie. I'm a rising 2L at Georgia State.
Well, welcome. Okay, all right. Okay, thank you very much, Helen. Please all be seated. All right, first order of business we're going to take up this morning is the matter of of the search warrant of Mr. Johnson's computer. Mr. Delphine and councils who are similarly affected, Mr. Johnson sent us a doctor's note yesterday, which I will mark as the next court exhibit in order, which indicates that he, as you all know, he was involved in a fairly serious motor vehicle accident. And his doctor has put him off of work from the 18th of June through the 9th of July. And he anticipates he can return to full duty as of the 10th of July. So that's what we have at this point in time. I also have an email from Mr. Johnson. We sent him an invitation, given his medical, to join us via Zoom. And I'm going to include this as the next court exhibit in order. He sent this just to Mr. Kearns, my staff attorney. We sent a message to him as well as to Mr. Delphine, as is customary for to make sure there's no ex parte communication. He indicates, Mr. Johnson indicates that he's got some vision issues, and he's supposed to see a medical provider in about a week or so, next week, I think, and will let us know what his condition is at that point in time. So I'm going to include that as the next court exhibit in order. So I thought that what we would do this morning, councils, I'm going to do two things. I'm going to introduce you to the special master, Miss Allegra Lawrence Hardy. Madam, good morning.
Good morning, Your Honor.
This is going to be your special master. She is a member of the State Bar of Georgia and consistent with the statute that governs these particular proceedings. She is a member of the Board of Governors. So I am going to just introduce you to her. Madam, if you, between now and the next time, if you and your colleagues would also run a conflict check to make sure that.
Yes, Your Honor.
Okay. Okay, good. The thing that we'll need to do now, councils, is we're just I'm going to pick another date for the hearing to be continued to Mr. Delphine. I don't think you have any objection at this point in time, do you, sir?
No, Judge, I don't. In terms of conflicts, I am out the week of July 15th. I'll be lecturing for the Prosecuting Attorneys Council that week. But other than that, I don't have any conflicts until the end of August.
Okay. Councilors, given Mr. Johnson's, we may end up having to do this a couple of times because given his condition, I don't know whether or not his doctor is going to release him, or he's going to have other issues. But I was going to say we could do this on the 12th of July. Does that work for all of you? Miss Lawrence Hardy?
Yes, Your Honor.
Does that work for you, madam?
It does, Your Honor.
Okay, all right.
It works. It's good for the state, Judge.
All right, we're going to be in session anyways, council, so we just handle it before we handle hardships. Mr. Adams?
Judge, good morning again. Thank you. Keith Adams for Mr. Williams. At some point, I'd like to be able to address the court about any potential conflict between myself and Madam Special Master relative to her position on the State Bar of Governors and my position on the State Bar of Governors. May not be a conflict, and that regard, I'd like to address the court at some point. I can research it and just.
If it becomes an issue, yeah, I mean, yeah, certainly if it rises, please let me know.
Just put that in the court file.
Yeah, okay.
Some additional thought research.
Okay, all right. If there comes an issue or file something appropriate, we'll of course deal with it.
Yes, sir.
Okay, all right. Okay, so we're gonna reset this for the 12th of July at, let's just say 9:30. Does that work for everybody? Okay, all right. We'll go ahead and, Mr. Kearns, we'll send out a notice as well. And then we'll go ahead and get Mr. Johnson subpoenaed for that particular day and time.
Assuming any order of the court previously entered maintaining the status quo, maintaining the physical presence of the computer remains in force.
That's correct. In fact, just to complete the record on that issue, Mr. Johnson did in fact turn over his computer. It is still in the sealed evidence bag, and it is in the possession of my official court reporter, Miss Christina Weaver, and it will be in her possession until we have such hearing, and I make another determination consistent with whatever is ruled upon at that point in time. But that will stay in my possession until that hearing. Okay. Do I have any other inquiry of me, counsels? All right. So, Ms. Lawrence Hardy, we'll see you back on the 12th at 9:30. We'll be down here in 1C again. Mr. Duffon, we'll see you as well.
Thank you, Judge. And if I could, just wanted to, we're having, because I'm from Gwinnett County, having trouble with getting documents and filings currently through Odyssey here in Fulton County. We're working on that issue and hopefully it'll be resolved. That being said, if anybody files anything into the case as it relates to this matter, I may or may not get it. You could also send it to me by email as well, and send it to me that way if you file anything. But we're checking periodically to see if anything new has been filed, but it may not automatically serve me with any documents.
And what is your email, sir? Just so counsel have that.
Sure, it's Brandon, BRANDON .Delfont, DELFUNT @GwinnettCounty.com.
Okay. All right. Counsels, any other further ministerial inquiry?
Yes, I
All right. Mr. Harvey, consistent with your ask from yesterday, I'll go ahead and excuse you, sir, at this point. Okay? All right. Thank you, sir. All right.
May I be excused?
Yes, sir. You certainly may. Mr. Smith, you and your teammates can come back and take the tables. Mr. Brown as well. And good morning to both of you. Good morning to you. Mr. Randolph, sir, can you go ahead and summon juror 1486? We have juror 1486 and 1582 for show cause orders.
Yes, Your Honor.
All right. Christina, here you go. Hey, and Wes, why don't you follow the notice?
Yes, sir. Which juror this is 1486? Sir, no, I have stand by the podium, please.
Uh-oh, jurors in trouble.
All right, Ms. Lantos, this is juror 1486. What day was he originally supposed to be here? And I believe that he did not appear to fill out his questionnaire. Is that correct?
That's right, Your Honor. That was on, hope this is the right date, March 5th.
All right.
I'm sorry, May 5th. I'm sorry, Your Honor, May 5th,
Nathan?
yes.
Sir, why didn't you come back to fill out your questionnaire?
Sir, I was on the way to work and I had just got that job. I'm already currently still in my 90-day probation. And with the way it is now, I'm still trying to get money up. So right now, living is actually kind of hard. Money's scarce and I can't do
So
it.
you just decided you weren't gonna show up? It'd been better for you?
No, I called and it didn't seem like money.
Who'd you call?
I called the number that was on the paper.
Right, and did you get a response?
I did. I listened to all the numbers that were calling. It didn't sound like my number was
All
calling.
right, so what else did you do in order to solve your problem?
Nothing. Because
That's the challenge.
yes.
What do you think you could have done to solve your problem?
Probably called back.
All right, that's one. What else could you have done?
Nothing I know of.
You knew I was a trial judge in this case. Why didn't you send me or Ms. Von Kels or anybody that you saw in that letter an email saying, hey?
Actually, I didn't know who was in charge of anything. This is my first time doing this, so I have no idea.
But you knew who my name was because I told you that when you first came in, right?
No, I don't remember that.
You don't remember?
No,
So you weren't paying attention?
I was.
So you remembered everything? You remembered everything else but my name?
I didn't even remember my number because I thought my number was.
Say again?
I didn't even remember my number. I thought my number was like 19 something.
Young man, contempt is punishable by $1,000 and 20 days in jail. Is that what you think I should do to you?
No.
Everybody else decided to show up and fill out their questionnaire and plead their hardship. And more than likely, given your circumstance, you probably would have gotten excused. So what am I supposed to do with you?
I don't know.
Got any suggestions?
No.
What would you do if somebody didn't show up for work?
I mean,
No, with no excuse.
nothing can do.
What's that?
Nothing you can do.
Well, I could fire you. Certainly. Couldn't I do that?
Yeah.
Are you in high school? I mean, are you finished high school at this point in time?
Yes.
So what are you doing right now?
Currently working, trying to live. Sorry.
Working where?
Working at a place called Allegiance,
What do they do?
a janitorial company.
Okay. All right, sir. Jury service is really important, okay? And you need to participate in the process to completion. And that's what I'm pretty annoyed with you about, because you decided, well, I'm just going to do what I need to do. And I should just send you to jail for a couple of days, but I'm not gonna do that. What I'm gonna do is I'm gonna defer your jury service, and you're gonna come back for another day to jury service.
All right.
Fair enough?
Fair enough.
Counsel, you okay with that? All right, okay. All right, so Ms. Von Kels over here, our jury clerk, is gonna give you another date. You better show up for that, and you better complete it.
Understood.
Because you may learn something from it. It's really that important. We're the only country where we let ordinary citizens from all walks of life decide the fate of others, criminally and civilly. And that's a special thing to be able to do. And it's one of the asks that we demand of you as a citizen. Voting, jury service, paying taxes, it's all part of being a citizen, okay?
Okay.
And it's a really important part. And I hope you'll learn that, all right? So you come back, that'll satisfy this particular issue, okay? Any other questions?
No, sir.
All right, sir, I'm gonna excuse you. You can bring in 1582, please.
Your Honor, that juror has failed to appear. We have contacted him 4 times, we called 4 times and left a voicemail. We've not been able to reach him.
Okay, juror 1582 counsels was in fact served and looks like signed personally for that on the 8th of June. I'm going to issue a warrant
Whoa, a
That
warrant.
juror failed to show.
Oh my
So that'll be
God.
1583. I'm sorry, 82. All right? Okay. Then when that juror is picked up, I'll deal with that particular individual accordingly.
Oh
All
wow.
right.
Do you guys want to hear some more of the jurors' woes? Yeah, there's a lot of people struggling out there.
19, I understand, are you training interpreters here, is that correct?
I'm sorry, Your Honor, I missed that both jurors are here and both jurors are.
Yeah, that's what I was gonna do, 1419, and I was asking if your Ukrainian interpreter is in fact present, which you just said yes, is that correct?
Yes.
All right, yeah, let's go ahead and take care of them, please. All right.
Чекайте, маленькими реченнями говоріть. Я буду перекладати все. Добре. Ні, українською.
Bear with me just a second. Oh, Mr. App, so glad you could join us this morning. Good morning, sir.
Good morning, Your Honor.
Okay.
А він поздоровкався з адвокатом, який приєднався до нас. Голосніше говоріть, для нього, добре.
Ma'am, what's your name?
My name is Larissa Hornbeck.
Miss Colbeck?
Hornbeck.
All right, okay. All right. Miss Colbeck, can I get you right here for me, please? You solemnly swear or affirm you shall well and truly interpret those responses from Ukrainian to English and English to Ukrainian to the best of your knowledge and belief?
Yes, I do.
Okay, and you're a state certified,
Oh, sorry.
Yes.
what's the language?
Russian and Ukrainian, I speak both.
Okay, all right. All right, madam. If you could tell our juror 1419 good morning for me, please.
Доброго ранку, пане 14-19. Good morning.
And sir, juror 1419, you are a U.S. citizen, is that correct?
Ваш номер 14-19, і ви є громадянином Америки, так? Yes.
When did you take the citizenship exam?
Скажіть, а коли ви склали іспит на отримання громадянства? Українською. In 2019.
Okay, you take it in English?
Ви склали його англійською? Yes.
And when you came to listen to the juror video, were you able to understand it?
А скажіть, коли ви прийшли і переглядали відео для присяжних, чи ви його зрозуміли?
Частково.
Partially.
Okay. All right. Mr. Brown, anything?
Nothing to see.
Anything further about any individual defendant?
No, sir, no.
Can I excuse juror 1419 for hardship?
You may.
Sir, we're going to excuse you for hardship, okay?
Добре, пане 14-19, ми вас відпускаємо через ці обставини.
Thank you, sir.
Дякую, пане.
1914, Mr. Randolph, please, sir.
Yes, Your Honor.
Thank you, sir.
Sure, thank you.
My name is Olga Gorenstein.
Olga Weinstein?
Gorenstein.
Weinstein, okay. Ms. Weinstein, can I get you to stand up for me, raise your right hand? Solemnly swear or affirm you shall well and truly interpret those responses from English to Russian and Russian to English to the best of your knowledge and belief?
Yes, I do.
Are you a state certified Russian interpreter?
I am nationally certified in medical field, trained to interpret in legal field as well.
Okay, all right. You can have a seat. All right, madam, if you would tell your 1914 good morning for me, please.
Доброе утро, номер 1914. Good morning.
All right, and Sir, are you a United States citizen?
Являетесь ли вы гражданином Америки? Yes.
When did you take the citizenship exam?
Когда вы сдавали экзамен на гражданство?
2013 год.
2013.
All right. Take it in English?
Вы сдавали экзамен на английском?
Да.
Yes.
All right. And for your job at Siemens Mobility, do you speak English or Russian?
На вашем месте работы в Siemens Mobility вы разговариваете на английском или на русском?
У меня есть небольшой запас английского, который достаточно. Я работаю сборщиком, и тот словарный запас, который у меня есть, мне достаточно для моей работы.
I speak a little bit English, just enough to go about my work duties. I assemble things and I have enough vocabulary to go about doing my job.
Okay. How much of the juror video were you able to understand?
Какую часть видео, которое вам показывали всем присяжным заседателям, вы смогли понять?
Ну, я понял только, что речь идет о уличных гангстерах.
All I was able to understand that it was something about street gangsters.
He said
How much
street.
were you
He
able
said
to
street
understand a portion of it?
gangster.
Is that what you're saying?
Правильно ли я понял, что вы говорите, что вы только лишь частично поняли это видео? Yes.
Mr. Brown, anything else? Anything else on behalf of any individual defendant? May we excuse juror 1914 for hardship?
Можем ли мы 19-14 освободить от этих обязанностей? Все согласились, сказали да.
Okay, we're going to excuse him for hardship. Wish you the best, okay?
Мы освобождаем его от этих обязанностей.
Спасибо.
Thank you.
1694, Mr. Randolph, please, sir.
Yes, Your Honor.
Sorry. You can have a seat. Thank you.
Juror 1694, good morning, madam.
Good morning.
Madam, you were identified for hardship, and I understand the basis of that is that you were a caregiver for a small little one, and you have an affidavit. Is that correct?
Yes, sir.
All right, can you hand that affidavit to Deputy Ingram for me, please? Thank you. How old is your little one?
He is 18 months.
18 months, all right. And you cannot make any alternative arrangements for the care of that little one, is that correct?
No, sir, I'm still breastfeeding him.
All right, okay. Consistent with that, ladies and gentlemen, juror 1694 has a properly executed affidavit which indicates that she is a primary caregiver of a child 6 years of age or younger. And with her testimony, do I have any other reason to examine her, Mr. Brown? Anything else on behalf of any individual offender? May I excuse juror 1694 for hardship?
Yes, yes.
Okay, I'm gonna excuse her for hardship and wish you the best, okay?
Thank you.
All right, thank you very much. $17.95, Mr. Randolph, please, sir. Thank you, sir. Yeah, those are the earlier contempt. Juror 1795, good morning.
Morning.
Sir, I understand that you just had a birthday. Is that correct? Back in March?
Yes, sir.
We have a little bit of information about you, and you were happily retired. Is that right?
That's correct.
And you are the young age of 75. Is that correct?
That's correct, sir.
All right, you have an affidavit. Did you bring today?
Yes, sir, I do.
All right, can you hand that to Deputy Ingram? And this affidavit says that, you know, we just talked about that, you're over 70 and you wish to be excused from jury service. Is that correct?
Yes, sir. Yes, my wife and daughter been ragging on me. You're a 25-year law enforcement officer, and yet you think you need to not do jury duty.
Now, I'm gonna let them have that conversation in private with you, but if you tell us that you wish to be excused from these proceedings, given the fact that you have attained a certain age which qualifies you for that, we will all part as friends, okay?
Yes, sir.
All right, so is that what you want to do?
Yes, sir.
Okay, all right. Counsels, I have a properly executed affidavit for our juror 1795, and given his birth date and this affidavit, do I have any other further examination I need to make of him? May I excuse him for statutory purposes? Okay. Juror 1795, sir, we're going to excuse you and wish you the best, okay?
Thank you, sir.
You're very welcome. $17.10, please.
Yes, Your Honor.
All right, juror 1710, good morning, ma'am.
Good morning, Judge Granville.
Madam, you've identified for hardship, and I want to say the basis of that hardship is that you are the caregiver of a son who is disabled, and you have brought in an affidavit. Is that correct?
I have, sir.
Can you hand that to Deputy Ingram for me, please?
Yes, sir.
Thank you, sir. All right, councils, it appears that, how old is your son at this point in time, Juror 1710?
He is 21.
Okay. Councils, Juror 1710 does have a affidavit for excuse or deferral from jury due to the caregiver of a person over 6 years of age. It has been notarized by her, signed by our juror and her physician, and notarized. Do I have any further examination I need to make of Juror 1710? May I excuse Juror 1710 for hardship? I'll include the affidavit as the next court exhibit in order.
All right, after this one, I'm gonna stop it and I'm gonna go ahead on and show you guys the motion.
You're excused at this point, madam.
Thank you.
All right, thank you. $16.35, Mr. Randolph, please, sir. All right, thank you, sir.
Okay, after this one, I'm gonna stop the video and just play you guys the show the motion that was submitted by the attorney. Hey, Wars.
Juror 1635, good morning, madam.
Good morning.
Madam, you've identified for hardship, and I want to say the basis of that hardship is twofold, travel and financial. Is that correct?
Correct.
All right. And madam, let's talk about the travel to begin with. Are you traveling anytime during the months of June, July, or August?
June. Yes, June and July, actually.
Okay. If I told you that we could excuse you for whatever dates that you have in June, July, would that resolve your travel-related hardship?
I'm sorry, what was the question?
If I told you that we could accommodate you for any dates of travel in June or July, would that resolve your travel-related hardship?
Travel-related hardship, yes, but not financial.
I didn't ask you about that
Okay,
yet.
sorry.
We hadn't gotten to that one yet. Okay, all right. There's a method to this. All right, madam. Relax, okay? It's not that bad, okay? Okay, all right. Madam, you've identified for financial hardship, but we have a little bit of information about you that's self-provided, okay? So you gave it to us. So if this is correct, you are a dentist and do you own your own practice?
Correct, yes.
All right, madam, are you a PC, LLC, some other type of entity?
LLC.
Okay. Have any other dentists working for you other than yourself?
I have an associate
You have an associate dentist?
who is young and inexperienced.
Okay, all right. Gotta ask you some other questions, madam. It would ordinarily be none of my business, so please forgive me in advance, okay? Madam, how much did your practice yield last year? Ballpark, don't need to know the exact figure.
The practice, I think the production number was 1.6 million.
Okay, and what did you pay yourself?
175,000.
Okay, and gotta ask you some other questions. Like I said, ordinarily none of my business. You and your beloved own a home, have a mortgage.
But beloved, is that my 3 children?
I don't have a husband.
Okay, well, okay, it has, okay, and this is why, you know, we ask these kind of questions, because in this block here, we've got just married, so some of this stuff is just wrong, okay? So you're not married?
Not married. I have my divorce decree.
Okay, all right, so your status has changed, that's fine. Okay, so let me rephrase that question. Do you own a home and have a mortgage?
I do own a home. I do not have a mortgage.
Do not have a mortgage. All right, other than the associated costs of owning a home, even without a mortgage, do you have any other extraordinary expenses such as a car note, private school tuition, tax, 941 tax payments, anything such as that you make on a monthly basis?
Yes, sir.
All right, how much are we talking about?
Car note is in excess or around $500-600 a month. Private schools are 34 plus 36, about $7,200 a month for the 3 children.
Okay.
And I have employees that I pay every 2 weeks, about $30,000 biweekly. I have a rental agreement, which if I die or get disabled, they will come after my estate and my kids to get payment until 2027, which hovers around $6,000 a month. My practice that I own, that I just purchased in 2021, November, for $550,000. I owe about $800,000 in loans, and then another $300,000 in equipment loans, and I would default on all those loans.
Okay. I think that's plenty at this point.
She ready to give it all, y'all.
And I need to ask you a couple other questions. How much in checking and savings do you have at this point?
I just checked. My personal checking account has $4,100 and some dollars.
Okay.
Savings has $16, I think, or maybe $26. Don't have much of savings.
Okay, all right. Sounds like you're doing a lot of capital investment for the short term, for the future. Now, would it be fair to say that if you were here, as you mentioned earlier, this would kind of decimate your practice if you were here for any length of time, correct?
Correct.
And would that cause you to lose at least, in terms of salary, about $80,000 in salary if you were here for up to 6 months? Would that be fair to say?
Yeah, probably more. I lose all my employees.
Okay. And in addition to losing your employees and kind of having an issue paying some of the debt that you're servicing at this point in time, would that cause you to be in financial peril or concern?
Yes, sir.
And would that financial peril or concern affect your ability to come into the four walls of this courtroom and provide these parties and their interests with your undivided attention?
Absolutely.
And do you believe that this could or would affect your ability to be fair and impartial both to the state as well as to the individual defendants in this case?
Yes, yes, sir.
All right. Mr. Brown, anything further? Anything further on behalf of any individual defendant? And I excused your 1635 for hardship.
Yes, sir.
All right, madam, we're going to excuse you for hardship. Wish you the best, okay?
Thank you, Judge Granville. God bless y'all.
You're welcome. Thank you, madam.
Your Honor, could we take a brief comfort break now?
You're always that guy. Always that guy. Okay, yes, we can take a break. That's fine. Okay, all right, okay. We're in recess. About 10 minutes, okay? Ms. Von Kelch? Hey, Wes. You know what?
All right, guys. We're gonna end this for the viewing stuff, and I'm gonna go ahead and bring up the paperwork. The paperwork, guys. You know, there are tons of motions that have been filed on this case, and there's a ton of them still have not been heard. So the most recent motion that has been filed is on behalf that has been filed by Young Thug's Jeffrey Williams' attorney. And I'm going to give you guys a chance to see what those motions are. All right. The first one is, let me just put it up for you guys. And I don't know if I'm doing it in order, but I'm putting it up for you guys so you guys can see. Okay, here we go. All right, let me, you know what? Let me take a look at your notes in here because you guys have been speaking, and thank you for the interaction, guys. It's been great seeing some of the stuff you guys are putting in here. One of the things I did see, I saw something that Earl put in. Earl Green says that slime life, young slime life, that thou be you prejudice and discrimination in court amongst the jurors. That'll be you prejudice and discrimination in court among the jurors. Oh, he says that will, but you discriminate by you discrimination and among the jurors. Okay. That will, I guess you meant to say that will buy you, like B-U-Y, right? Okay. And okay, you're right. That was by. Only way he will find a juror if he just get all retired wealthy people. Only way. You know what? I must agree with you on that one, Lamar. I must agree. Foreigners getting money off our backs. Okay. All right, musician. Okay. Music insertion. Okay. All right. Earl said, I told my creditor the government defaulted, so what do you expect from me? One creditor was talking shit and said, Earl, get from under the bed. You're oh, you melon head. Exactly, Lamar. And then one could argue it's not a juror of their peer. And Lamar's Green says, Sierra, yep, exactly. Why this case is complete mess. Okay. I was reading some of you guys' messages, so I didn't get all the way up to the top. All right, let's go ahead on and take a look at this this paperwork here that was submitted, this motion that was submitted by Mr. Steele. And it says United States versus Jeffrey Williams, ETAL, defendant. It says the indictment number 22SC183572, Judge Granville. Special demurrer / plea in bar / joint motion to strike based upon the statute of limitation. Now come Mr. Jeffrey Williams by and through undersigned counsel, and hereby files this special demurrer. What does it mean, demurrer? Demurrer. Anybody know what demurrer means? Let's go look it up. Hold on, I don't know what that is. Demurrer. Demurrer. It says the objection that an opponent's point is irrelevant or invalid, while granting the factual basis of the point. I still don't tell me what it means. The headmaster was entered into a single memorandum. Okay, that doesn't make sense to me. Can anybody explain it? Okay, demurrer refers to making a pleading that challenges the sufficiency or accuracy of pleading on another party. Demurrer typically comes in two forms, generally and specific. A general demurrer challenges a broader problem with a pleading that affects all the claims brought, such as improper venue. I still don't know what the heck that means. Anybody can figure it out what it mean to me? Where's Q at? Where's my buddy Q? Q, where are you? I still don't understand what that means. Anybody knows what that means? I'm gonna put the link in now. You guys, I know I told you I'm not an attorney. Let me see if I can give another example of a demurrer. Okay, let's see. If a plaintiff files in a case in Superior Court and the fact that in the complaint it does not state a cause of action, that is, they give no legal basis for the defendant to be held responsible for any damages claimed by the plaintiff. Okay. I think I got it now. I think I got it. I'm going to give you one. It's going to give me one more thing here. It says if a plaintiff files a case in Superior Court and the facts of the complaint do not state a cause of action, that is, they give no legal basis for the defendant to be held responsible for any damages claimed by the plaintiff. The defendant may bring a demurrer asking that the case be dismissed. If a cause of action has been stated, the Superior Court overrules the demurrer and the case continues on. If no cause of action has been stated by the court, but the court believes that there's more facts that will enable the plaintiff to state a cause of action, the court sustained the demurrer with leave to amend. Okay, so they get a chance to amend it, in which the case, the plaintiff can restate his or her case in an amendment complaint. If the court believes the complaint does not state a cause of action and cannot be amended to state a cause, the court will sustain the demurrer without leave to amend, and the case is dismissed. Okay, so they basically saying that the state has not given the state of cause of an action. So I guess it's saying that the stuff that the government is giving is fluff. All right? That's what you think. Does it mean that? Does it mean that it's like a bunch of bull? And there's no real substance behind what the state is claiming in regard to this case. There's no real cause of action, right? Help? Somebody help? Help me. Help. I'm asking you guys for help. Hey, Queen Dots, the world. Can somebody help me on that one? Because I told you guys, I'm a layman. I don't know this stuff. I don't know nothing about this. So what do you guys think? Does it mean that? Why did Judge Granville allow the prosecution to include dates outside the statute? Just read it first. Okay. She said just read it first and then we'll figure it out. Okay, now comes Mr. Jeffrey Williams by and through undersigned counsel and hereby files the special demurrer plea in bar joint motion to strike all overt acts which are barred by the statute of limitation in the above referred case. In support of this special demurrer, plea in bar motion to strike, Mr. Williams shows as follows. Mr. Williams is innocent of all charges in the above referred indictment. 2. In order to satisfy the crime of a RICO conspiracy, the prosecution must prove beyond a reasonable doubt that at least one overt act was committed in furtherance of the conspiracy within the statute of limitation. See Pasha v. State. And in the case number, to satisfy the statute of limitation, the overt act must occur within 5 years of the filing of the bill of indictment by the clerk of court, COCGA 16-14-8. And then it has a footnote here. Based upon the information and belief, all indictment joined in Mr. Williams' plea and bar joint strike to motion to strike filed within here. Okay. Number 3. In the case at bar, the grand jury alleged 191 days overt act. See Bill of Indictment, page 14 through 67. Number 4, approximately overt act number 62 through 191 are alleged to have occurred on a date within 5 years of May 9th, 2022. The date of the original bill of indictment as well as the re-indictment. The re-indictment was filed in the Fulton County Clerk of Court on August 5th, 2022. See the original indictment number 22SC182273. Number 5. Both the original indictment as well as the re-indictment have overt acts number 1 through approximately 61 with a date more than 5 years before the returning of the indictment. See re-indictment's original indictment number 22SC182273. Number 6. Since overt act number 1 through about 61 are outside of the 5-year statute of limitation, these overt acts cannot support a conviction of Mr. William or any of the accused. Since said overt acts were outside the 5-year statute of limitation, see OCGA 16-14-8. Number 7. Mr. William can bring this plea in bar motion to strike pretrial. See Jenkins versus State 278, Georgia 5981, and then a bunch of numbers after that. State versus Tuzeman. Number 8. The inclusion of any overt act dated before approximately May 2017 in other crime evidence barred by the applicable statute of limitation and is prejudicial to Mr. William and has no probative value. Hence, same must be stricken from this indictment pursuant to this special Demermer statute of limitation plea in bar. Number 9. Any overt act that occurred more than 5 years before the return of a bill of indictment violates the statute of limitation, as same cannot be seen as overt act in support of a conviction. Therefore, since the overt act must be proved beyond a reasonable doubt to have occurred on or by approximately May 2017, any overt act before May 22nd, 2017 must be stricken from the indictment. See Young versus State. State versus Conzo, that's another case. Number 10. Moreover, the grand jury alleged in relevant part the following as one of the objective of the conspiracy: preserving, protecting, and enhancing the reputation and power of the enterprise. See re-indictment, page 12. None of these objectives are permitted by the statute and hence must be stricken from the indictment. See OCGA CGA 16-14-4 A, B, and C. 11. By filing this special demurrer, Mr. William is entitled to an indictment perfect in form and substance. Thomas versus State. The inclusion of other bad acts, crimes in the indictment from approximately May 2017 that will presumably be presented with the deliberating jury prejudices Mr. William as uncharged conduct and time-barred overt act now wrongly invade the jury's deliberation room, similar to a continuing witness. Wherefore, Mr. William respectfully requests that this honorable court to hold a hearing for this special demurrer plea in bar motion to strike basis on a statute of limitation, and at the conclusion of the same seek this honorable court to grant the above request relief. This 23rd of June 2023. Respectively submitted, Brian Steele, Keith Adam, attorney for Mr. William. Okay. All right, so let's go read some of what you guys put in here. You think they're going to let Thug go? I'm not sure. I don't know. Jennifer says Judge Granville is biased. Jennifer says Jeffrey Williams' rights have already been violated by being locked up in solitary confinement for over a year with no bond. Okay, Jennifer. All right. Anyone else have anything to say before I read the next one? Anyone else have anything to say before I read the next motion? All right, let's do the next motion. Okay, summary. Oh, that was. Sorry, that's not what I was trying to read. That wasn't it. Oh, sorry. All right, the next one is right here. And it is the motion to suppress number 9. All right. I'm not going to read the title and, the name. You already know what case this is, okay? Motion to suppress number 9. Now comes Mr. Jeffrey William by and through undersigned counsel and hereby files this motion to suppress any and all evidence obtained from T-Mobile for Mr. Williams' telephone number ending 3904 pursuant to the May 16, 2016 search warrant issued by the Honorable Judge Millender. In support of this motion to suppress number 9, Mr. Williams shows as following. 1, Mr. Williams is innocent of all charges and in the above referenced indictment. Number 2, Mr. Williams has standing to bring this motion to suppress as he is the owner of the telephone number ending 3904. Number 3, on or about May 16, 2016, Appellant Detective David H. White submitted an affidavit in support of a search warrant for Mr. Williams' cellular telephone record that includes cell tower call logs, call detail reports, range to tower and round trip delay data, text message transmission and receipt log and contact if available, and subscribers information for Mr. Williams' telephone. Said search warrant was signed by the Honorable Fulton County Superior Judge Millender on May 16, 2016. Number 4, the affidavit in support of the search is conclusory and fails to allege any specific expert generalization as to where there is probable cause to believe Mr. Williams' cellular phone ending in 3904 would relate to evidence of the crime of murder that occurred on or about January 10th, 2015. Number 5, the affidavit simply wrote that it is believed that the insurance of a search warrant compelling T-Mobile USA to release the record associated with Mr. Williams' cellular phone number as a result in recovering of the evidence related to the crime of a murder, appellant wrote. Generally, that it is customary for people to carry their cellular device with them at all time. It is for this reason. Remember I was telling you guys about that yesterday when I was talking about, how they use that thing against us now. We carry that phone. This phone could be at our detriment. We can be caught in a crime, a federal crime, because of these things here, these phones. Remember I told you guys that? Okay. This is a perfect example right here. When they did the search warrant, they're saying that basically we carry our phones everywhere we go, right? That's what they're saying. Okay. Let me see. Let me go back down. Where am I? Okay, it's believed that Mr. William on the date and time of the murder, as well as the days immediately preceding and following the murder, will reveal cellular tower data that will aid in approximating Mr. Williams' whereabouts during the applicable time frame. In addition, the records request in this warrant will also reveal the number called by Mr. Williams at or around the time of the homicide, which will aid in identifying other suspects and co-conspirators. The above has no relations except generality without any specifics as to why the search warrant was probable cause to believe that evidence of a crime will be located. Wherefore, Mr. Williams respectfully requests a hearing on this motion at the conclusion of the same. Ask the Honorable Court to grant the above request relief. Hold on a second, y'all. Sorry about that, guys. That was me daughter. Me daughter was on the phone. I'm sorry. But I think that was it. I finished reading it, right? That was basically they asking the judge to strike or throw out, suppress, throw out, get rid of the that cellular search warrant stuff because they had no probable cause for even getting that that search warrant. Search warrant was not. I mean, they did it after the fact because search warrant is supposed to have been done before to pinpoint. There was no real reason for them to do a search warrant for the phone because the phone doesn't. I don't know. So I read it. What do you guys think? What do you guys think about that? You know what? I'm gonna put the link in. Anybody who wants to come in, come on in. That other case is back up yet? Because I wanted to see that one. Is it back up? Okay. Those of you guys that no, I'm gonna go behind the scene on this one. I'm gonna go behind the scene on this one. All right, so you wonderful people. Is there anything you guys, any question, concern? Any thoughts? All right, so I'm gonna end and I will see you guys later if I get any kind of updates in regards to Young Thug's case, any case that I'm working on, that I will come back and bring you guys update, okay? Sounds good? All right, you guys have an awesome day. God bless. Bye.